I am Hank Chambers. I am from the University of Richmond. I teach law here. Great to see you. I'll be the chief today for you all. And let's see hear from our other two before we hear from you all.
Hi, I'm Ann Zinkin. I'm a career law clerk at the New Hampshire Supreme Court, and am married to a guy from Ann Arbor, so have again is dear to my heart.
Good morning. I'm Barry Anderson. I'm an Associate Justice on the Minnesota Supreme Court. Long connection with this program, both as a judge, but also as a coach many years ago. So I see your side of the equation. I'm going to suggest to my two colleagues and Ellen that we make sure we mute because we're getting some feedback, and I suspect that's because of multiple speakers and so forth. So we'll try to remember to do that. Delighted to be part of your day.
Absolutely. So tell us about yourselves. Where you're from?
Hi, I'm Anna Carroll. We're super excited to be here. I go to East Kentwood and I'm a senior.
I'm Sam Wakeman. I'm also a senior at East Kentwood High School.
And I'm Samara Mudrick. I'm also a senior at East Kentwood High School, and our coach is Mr. Justin Robbins.
Fabulous. Well, we look forward to hearing your testimony. This is Unit 4. So let me go ahead and read the question, and then we will get your 4-minute opening. Unit 4. It would be inconsistent with the constitutional separation of the executive and legislative powers to let the prerogative, pardon power, be exercised by the latter. What were the framers' reasons for giving the president the pardon power, and do you agree or disagree with them? According to the framer, James Wilson, if the president abuses the pardon power, he can be impeached and prosecuted. Do you agree with Wilson? Why or why not? In your opinion, what constitutes high crimes and misdemeanors? We're ready for your opening statement.
We agree in principle with the framers' decision to grant pardon power to the president, but are concerned about modern examples of its exercise. Pardon power represents a considerable use of executive discretion and stretches back at least as far as ancient Babylonian kings offering this harm in the 18th century BCE.
The Romans adopted a pardon system with political elements, and William Blackstone later explained that this influence led to Henry VIII's nearly unlimited pardon power in England. As a result of their extensive education and colonial experience, the framers were acquainted with pardon power as the royal prerogative of mercy.
In fact, colonial governors wielded pardon power as representatives of the king, demonstrating both the power and peril of vesting such important discretion in one executive figure. Later, early state constitutions reversed course, imposing limits on governors' powers of clemency as a trend towards emasculated executives.
However, as the only nationally elected official in the new nation, the president was granted broad pardon power in Article 2, Section 2 of the Constitution. In Federalist 74, Alexander Hamilton explained two major benefits of pardons.
First, as a check on the judiciary so that it did not wear a countenance too sanguinary and cruel. This intention was pursued by President Obama's nearly 1,700 pardons, which were granted to nonviolent drug offenders sentenced under outdated laws.
Secondly, pardons may advance the nation in wake of insurrection or crisis, when a well-timed offer of pardon may restore tranquility. For example, George Washington granted amnesty to participants in the Whiskey Rebellion, and Andrew Johnson pardoned Confederates following the Civil War to move the nation forward in a way Congress could not.
However, in Anti-Federalist 74, George Mason warned that the president ought not to have the power of pardoning because he may frequently pardon crimes which are advised by himself, and demanded the case of treason ought to be accepted.
Madison responded that if the president be connected in any suspicious manner with any person, the House of Representatives can impeach him. To ensure this, Article 1, Sections 2 and 3 of the Constitution give the House of Representatives power of impeachment and install the Senate as the sole court for impeachment trials, respectively.
Federalist 65 further explains that impeachment should be pursued for abuse or violation of some public trust relating to injuries done immediately to the society itself, a standard that clearly covers abuse of pardon power.
However, we disagree with James Wilson that impeachment serves as a meaningful check on the president's pardon power. For example, in modern times, controversial pardons are granted at the end of a president's term, when there's little time for an impeachment proceeding.
Additionally, the framers' belief that the mere threat of impeachment would govern a president's behavior out of virtuous concern for their legacy is unfounded. When 4 formal impeachments have failed to produce removal, and specious pardons for half-brothers and campaign officials have drawn no consequences, we reject the assertion that impeachment is a serious factor in presidential discretion.
Viewing impeachment as a check is further complicated by disagreement about when to pursue it. At the Constitutional Convention, delegates considered maladministration and neglect of duty, and treason, bribery, and corruption, but eventually included high crimes and misdemeanors as the constitutional standard for impeachment.
We believe high crimes and misdemeanors does not require a commission of a crime to pursue impeachment. For example, 2 of the 11 articles of impeachment against President Andrew Johnson reference non-criminal offenses.
Instead, we believe high crimes and misdemeanors include deliberate corruption or violation of the oath of office due to action or inaction by the executive. These offenses must be impeachable to pursue Madison's intention of defending the community against the incapacity, negligence, or perfidy of the chief magistrate.
Thank you for listening. We are ready for questions.
Thank you so much. Judge Anderson, you want to go first?
I'd be happy to go first. Should the president's pardon power be limited?
Say that the president's pardon power shouldn't be limited because it was originally based on the royal prerogative of mercy, which the framers looked back on by the British Parliament.
Additionally, the pardon power does serve as a check on both the legislative and the judicial branches. And so by limiting the pardon power, it lessens the check on the branches and doesn't allow for instances like President Obama's 1,700 pardons on non-violent drug offenses to occur.
Yeah, it presents a conflict with separation of powers if the pardon power, which is used by the executive to check the legislature and the judicial branch, is then checked by the other branches.
Moreover, the royal prerogative of mercy and having the ability to have this check and balance allows for prisoners, especially in cases of non-criminal drug offenses, to restore their natural rights when they are in prison, natural rights according to John Locke.
Let me just follow up on that very quickly. But what do we do about pardons that are abusive? Is that just the cost of admission?
Sadly, there have been definitely very abusive pardon powers. This can be seen with Clinton pardoning his half-brother, and moreover, him pardoning Mark Rich, someone who donated to his campaign. A check that was originally founded by the framers would be impeachment, but sadly, since we haven't had impeachment that's gone perfectly, other than perhaps Nixon, but he resigned before we could even have a bipartisan impeachment, we don't have a precedent for these types of pardons.
Yeah, unfortunately, as Anna mentioned, impeachment is the only formal check on the pardon power by the executive. And because we've had 4 impeachments that have yet to produce removal from office, we wouldn't say that impeachment is necessarily serving as the most effective check on this power.
Okay, thank you for your response, Professor Chambers.
I'm curious. Can you explain why? Sorry, give me one sec. Can you explain why the Mark Rich pardon and the Clinton half-brother pardon were abusive?
Sure, definitely. So the reason why we have pardons, as I mentioned before, is royal prerogative of mercy, and moreover because the executive was based upon somewhat having power. And Thomas Hobbes has this really brilliant idea in which executives should be virtuous and that they represent the common people and should look out for the common good. Well, those pardons didn't look out for any common good except the president's own actions and own will.
And one of the anti-federalist fears by George Mason specifically was that presidents would pardon crimes that were advised by themselves. And by President Clinton pardoning Mark Rich, who was a large donator to his campaign, it wasn't necessarily an abuse of his power, but it was seemingly corrupt, especially when there was no formal explanation as to why the pardon was granted.
And also in the case of his pardoning of his half-brother, Roger Clinton, he was originally sentenced for cocaine trafficking charges, and those still have today some pretty serious sentencing associated with them. And so the excuse that, well, these drug crimes are now more societally acceptable doesn't really apply.
Okay. Judge Lincoln, what you got for us?
I'm wondering whether you think the framers intended to allow a president to pardon himself or herself, and If so, where do you find that in the presidential pardon clause? And if not, sort of on what basis do you say that the framers did not intend it?
The framers definitely did not intend for the president to be able to pardon themselves. There are debates about this during these times, and it's just evident that in the way that the framers were thinking about having an executive so that is elected to be able to pardon himself would definitely contradict this, the idea of a virtuous executive. Moreover, the idea of having an executive that can pardon himself definitely removes himself from the state of law that applies to everyone. And even executives and congresspeople and people within our government should still be held to these standards.
I think that allowing a president to pardon him or herself would set a dangerous precedent because, I mean, if the president can commit a crime and then pardon himself, what really is there stopping him or her or future presidents from committing more crimes and not really having to fear being impeached because he can just pardon himself?
All right, Justice Anderson, what you got?
Yeah, I want to ask about the fact that the judiciary was almost entirely excluded from the impeachment process by the framers, other than presiding over the Chief Justice presiding over the Senate trial. Why did they do that, and was that a good idea?
The reason why they separated the justice system, at least, and especially the Supreme Court, from this in impeachment proceedings, because the justices are directly put into that area by the president himself. So there could be conflicts of interest, especially if it's a judge that was elected by that president and then they have to impeach that president.
Additionally, the judicial branch was intended to remain as the neutral and nonpartisan branch. And by throwing them into the impeachment process, as we've seen with our past 4 impeachments, they haven't been the most virtuous and they've been fairly partisan. And by throwing the judicial branch into a partisan impeachment, it takes away from the fact that they're supposed to be our nonpartisan branch, as the framers would have intended.
So are you suggesting the Andrew Johnson impeachment was partisan?
Yeah, we believe so because obviously there was a lot of strife between Johnson and the radical Republicans of the time based on their Reconstruction policies clashing strongly. And so the Republicans already kind of had it out for Andrew Johnson, and they kind of almost backed him into a corner with the Tenure of Office Act, which was later thrown out as unconstitutional, but they kind of wrote this law so that because they knew he would break it.
Okay. Okay. So, curiously, why does the Senate have to vote 2/3 for conviction, but the House only needs a majority for the original impeachment? Does that make sense to you?
I would believe that because the House was intended to be closer to its citizens back home, that the House is more subject to the tyranny of the majority. And by having the Senate have a stronger voting process, it somewhat subdues the chaos of the House and allows the proceeding to be more legitimate.
And prior to the 17th Amendment, the Senate was not directly elected by the people, instead by state legislatures. So at having that extra layer between the people and the legislature kind of creates a higher standard, because there may be states that don't like it, but that might not necessarily reflect the will of the people.
Should the House of Representatives be required to have more than majority in order to impeach?
Because the House is closer to the people than the Senate, well, I mean, I guess today they're both directly elected, but I can finish my thought.
Yeah.
Because it's closer to the people, or at least in intention, I think that it should not be necessary, because a 50% majority would, in theory, maybe not in practice today, with today's polarization, would in theory be closer to the will of the people.
All right, thank you. Appreciate it. So Judge Zinkin, what you got?
So thank you so much. That was a really interesting conversation that I appreciated being a part of. I thought your opening statement in particular was really impressive. I really loved how you weaved examples from history with current examples. And I thought you demonstrated really good depth of knowledge. And I appreciated the question and answer period and how you were sort of able to reach back to some of the things you talked about in your statement and sort of elucidate further on some of those points. So I thought you did a great job, and I really appreciated all your hard work.
Go for it, Justice Anderson.
Complicated thing there to unmute my microphone. I really liked your opening statement. I like the focus on, we sometimes lose sight of the fact that we build on the other traditions, and in the case of our founding era, the royal prerogative, the divine right of kings, all of that stuff is a piece of this, at least in the background. And I really like your comment about the use of the pardon power in a crisis situation, or another way to put it would be sort of in a redemptive situation to try to heal wounds and other things. There's some contemporary examples of that that are also, I think, some are also worth citing. I like the discussion about whether the president's pardon power should be limited. I think you could have gone a little further with that and pointed out that, well, yeah, you can maybe fix some problems with the president's pardon power, but if you do that, you may limit its utility in more unusual circumstances. But finally, I just wanted to say your comment about President Obama and those 1,700 pardons that he granted, that is a really good example of, you can argue about whether or not individually about those pardons, but it is a really good example of reining in his own Justice Department in some senses, because his Justice Department is also responsible for prosecuting. And so, yeah, I think that's a really good example, and I thought it was a great presentation. Thanks very much.
No, I agree. I really like the opening. I think it showed a lot of depth of knowledge and a lot of good work. The question and answer time, I think, went pretty well. There are difficult questions to answer, right? And difficult notions to get at. It was kind of interesting because as you continue to provide additional reasons and additional ways that presidents can use pardon powers, it starts to sound like the president can just use a pardon for policy reasons, which might suggest there's no real limitation on why the president can use the pardon power. But then you rolled back and said, well, but in situations with family members or with donors, there is a limitation. So, so setting some interesting lines where you want to use the power or not. But I think y'all did a really strong job of thinking your way through a lot of issues. And I'm sure you're going to have additional conversations to think about as well. So good to see you, and good to have this conversation. Appreciate it.